A deposition is a witness's sworn out of court testimony. It is used to gather information as part of the discovery process, and in limited circumstances may be used at trial. The witness being deposed is called the deponent. And I provided you with the Federal Rules of Civil Procedure that governs depositions, Rule 30. So let's look at objectionable questions. But before we do that, I want to turn your attention to quotations as you see here. Whenever you see a quote, I am actually quoting the National Law Review. I will put the National Law Review's link on the last page of this video as well as in the description page of this video. So the first objectionable question is a question that harasses the deponent. If the deponent is being attacked or harassed, the deponent have the right to object regardless of whether he or she is in a hearing or in a deposition. If the behavior continues, the deponent have the right to end the deposition. And that is a true statement. Years ago, early on pretty much when I started practicing law, I was in a deposition for my client. And the attorneys were belligerent. They were like over the top. And I said to them, if this continues, I am going to call the judge, because in that particular circuit, the local rules allowed us to call the judge. I did. I called the judge. Of course, the judge advised us and instructed us, and the deposition went on. I didn't have any more problems or issues after that. Now, before you do that, you want to definitely read the local rules to make sure that the circuit in which the lawsuit is filed allows for a deponent or the deponent's attorney to contact the judge and let him or her know what is going on. Asked and answered. Well, let me give you heads up. Do not be surprised if the defense counsel taking your deposition asks you the same question over and over and over and over again, and you have responded each time. How many times is too many? There is no magical number, but you must feel and know that you have answered the questions substantively. Here's the rule. If the attorney for the opposing party continues to ask questions that are simply reworded, the attorney may be attempting to get the deponent to contradict a previous statement. Asked and answered objections are proper in a trial and in a deposition. Use your discretion, but be prepared to defend your position. If it is a question about privilege in the deposition, if opposing counsel persists in this line of questioning, it is important to raise the issue of privilege because you waive the right to privilege if it is not raised as soon as a question is asked. That's important. Now, several weeks ago, I uploaded a video on privileged documents and how to keep them private. I will enter that link in the description page of this video. Form of the question. If you do not make this objection during the deposition, it is considered waived. You can object to questions that are compound or questions that call for speculation. Let me give you an example of a compound question. For example, the attorney asked the deponent, "Who terminated you? Did they give you written notice? Or did they verbally terminate you?" That's compound. And that would be objection to the form of the question. Another example is speculation. The deponent should never give an answer that consists of guessing. If you don't know, you don't know. Again, a deponent should object to any question that calls for speculation. Questions that call for legal conclusion. Let me say this. The deponent is at the deposition to testify about facts, not make legal conclusions. Only a witness who is an attorney can make a legal conclusion, and even this may be a gray area if the question is about an area of the law that the attorney does not practice. Typically, a deponent should not be required to make a legal conclusion, even in a deposition. So, if the deponent hears anything close to being asked to come to a conclusion regarding the law, or even coming to a conclusion, think objection, because it calls for a legal conclusion. Let's talk about 3 questions that are not objectionable for the purposes of the deposition, but they may not be admissible at the trial. Hearsay. What is hearsay? It is testimony given by a witness or deponent who relates not what he knows personally, but what others have told him or what he has heard said by others. Even though it's hearsay, it's allowed at the deposition, because what is happening, the attorney is trying to get to information that is admissible. However, at the trial, the hearsay information is not admissible. Why? Because the witness is not available to be cross-examined. Opinion. The attorney can ask the deponent for an opinion and ask the deponent or witness to explain how he or she arrived at their opinion. Assumptions. We're talking about facts not in evidence. The defense can ask a deponent questions about facts not in evidence. For example, if the attorney asks, "If you knew this, would it have changed what you did or how you acted?" Well, the deponent answers it as truthfully as possible. But the deponent is not required to speculate. Let's talk about 2 other potential areas where objections may be unacceptable. In the first one, irrelevant questions. Generally, there are no irrelevant questions, just generally speaking, unless the question is clearly way off topic. In court, the judge decides what is relevant and irrelevant when this objection is made. In a deposition, there is no one to make this decision. An objection for irrelevance is only acceptable if the question is clearly way off topic. In the case where the answer may lead to admissible evidence, irrelevant objections are not proper positions. So one, the deponent has to determine if the question is clearly way off topic. And if it is, he or she can object. But again, be prepared to defend your objection in the event the attorney files a motion to compel. The second one is confusing questions. The question is so confusing, the deponent can't answer it. While it may not be proper to ask for clarification, a question may be confusing to the point that the deponent cannot understand what is being asked. If the deponent cannot answer the question because it is too confusing to understand, an objection may be proper. Again, if the deponent is going to object on this ground, be prepared to defend your position. Now, I want to talk about some survival tips. This is really going to encourage you. 1, get you some sleep. Don't be up until 1 o'clock in the morning on the day of the deposition. By this time, you need to be ready. Okay? 2, you don't have to wear a suit, but look professional, because we are judged by our appearance. 3, expect the attorney to ask unrelated questions. Now, when you sit down and you're sworn in, the attorney first 20 questions maybe is going to be about you. It's going to be about your family. Are you married? By the way, if they ask you for your social security number, tell them that you want to give it off the record. You do not want it in your deposition. So they're going to ask you a whole bunch of questions, and you're going to be saying to yourself, what do these questions have to do with my deposition? Well, they do it for various reasons. 1, to get admissible evidence. We talked about that a little earlier. And they want to rattle you. So, unless it's a question that is way out of the way, where it's to embarrass you or whatever the case may be, you want to expect them to ask unrelated questions. 4, have confidence God will help you through this. I tell you, depositions, they are gruesome. I don't want to paint a pretty picture because it isn't. Whatever the rules allow in terms of how long they can have you in that seat, they will keep you there. So have some hope, confidence that God will help you through. Okay? 5, think before you answer the question that the attorney asks. Take your time. Don't feel rushed. Now, we don't want to do that all day, but you think. Don't just automatically answer the question. You think. That's important. Even if they make you feel like you need to rush, don't fall for it. Sometimes that's a tactic. Think before you answer. If you don't know, you don't know. Don't speculate. We've gone over that. 7, listen. If you need a break, ask for one. As long as you can provide answers, you do that. I've been in situations where my client just wanted minimal breaks. And then you have others who want more breaks. It depends on the person, but here's the point. If you need a break, ask for one. 8. If you do not understand a question, ask the attorney to rephrase the question. You answer that question only after you have a full understanding of what you are being asked. Okay? 9. Keep your answers simple, please, and only answer the question that is asked. You've answered it, seal your lips. Because what will happen if you keep talking, you're just going to open the door for them to ask more questions. And I know you might feel tempted to get a piece off your mind. Answer the question and wait for them to ask the next one. 10. Always be kind and be courteous. Let them know that you have control. Okay? That's important. You can do this.